President, members of the court, the nightmarish environment created by Hamas has been concealed by the applicant, but it is the environment in which Israel is compelled to operate. Israel is committed, as it must be, to comply with the law, but it does so in the face of Hamas's utter contempt for the law. It is committed, as it must be, to demonstrate humanity, but it does so in the face of Hamas's utter inhumanity. As will be presented by counsel, these commitments are a matter of express government policy, military directives, and procedures. They are also an expression of Israel's core values. And, as shall also be shown, they are matched by genuine measures on the ground to mitigate civilian harm under the unprecedented and excruciating conditions of warfare created by Hamas. It is plainly inconceivable, under the terms set by this very court, that a state conducting itself in this way, in these circumstances, may be said to be engaged in genocide, not even prima facie. The key component of genocide, the intention to destroy a people in whole or in part, is totally lacking. What Israel seeks by operating in Gaza is not to destroy a people, but to protect a people, its people, who are under attack on multiple fronts, and to do so in accordance with the law, even as it faces a heartless enemy determined to use that very commitment against it. As will be detailed by counsel, Israel's lawful aims in Gaza have been clearly and repeatedly articulated by its Prime Minister, its Defense Minister, and all members of the War Cabinet. As the Prime Minister reiterated yet again this week, Israel is fighting Hamas terrorists, not the civilian population. Israel aims to ensure that Gaza can never again be used as a launch pad for terrorism. As the Prime Minister reaffirms, Israel seeks neither to permanently occupy Gaza or to displace its civilian population. It wants to create a better future for Israelis and Palestinians alike, where both can live in peace, thrive, and prosper, and where the Palestinian people have all the power to govern themselves, but not the capacity to threaten Israel. If there is a threat to that vision, if there is a humanitarian threat to the Palestinian civilians of Gaza, it stems primarily from the fact that they have lived under the control of a genocidal terrorist organization that has total disregard for their life and well-being. That organization, Hamas, and its sponsors seek to deny Israel, Palestinians, and Arab states across the region the ability to advance a common future of peace, coexistence, security, and prosperity. Israel is in a war of defense against Hamas, not against the Palestinian people, to ensure that they do not succeed. In these circumstances, there can hardly be a charge more false and more malevolent than the allegation against Israel of genocide. The applicant has regrettably engaged in a transparent attempt to abuse the Convention's compulsory jurisdiction mechanism, and in particular, the provisional measures phase of proceedings, to bring under the purview of the court matters over which, in truth, it lacks jurisdiction. Madam President, members of the court, the Genocide Convention was a solemn promise made to the Jewish people and to all peoples of never again. The applicant, in effect, invites the court to betray that promise. If the term genocide can be so diminished in the way that it advocates, if provisional measures can be triggered in the way that it suggests, the Convention becomes an aggressor's charter. It will reward, indeed encourage, the terrorists who hide behind civilians at the expense of the states seeking to defend against them. To maintain the integrity of the Genocide Convention, to maintain its promise and the court's own role as its guardian, it is respectfully submitted that the application and request should be dismissed for what they are, a libel designed to deny Israel the right to defend itself according to the law from the unprecedented terrorist onslaught it continues to face, and to free the 136 hostages Hamas still holds. I thank you for your kind attention. May I ask, Madam President, that you call Professor Shaw to the podium.
I thank the co-agent of Israel for his statement, and I now invite Professor Malcolm Shaw to take the floor. You have the floor, Professor Shaw.
Madam President and members of the court, it is a great honour to appear before you again and a privilege to appear on behalf of the State of Israel. It is my task today to address the issues falling within the general categories of prima facie jurisdiction and the preservation of alleged rights sought to be protected. However, I would like first to make a preliminary comment about the key question of context. It constitutes the framework for the consideration of this request for the grant of provisional measures. South Africa casts its net widely. In its application, it uses the word context many times. In particular, it declares that it is important to place the acts of genocide in the broader context of Israel's conduct towards the Palestinians during its 75-year-long apartheid. Leaving aside the outrageous nature of that statement, why stop at 75 years? Why not refer to 1922 and the approval by the Council of the League of Nations of the British Mandate? Or 1917, the proclamation of the Balfour Declaration? Maybe also include the entry into the land of Israel of the Israelite tribes some 3,500 years ago. No. The immediate and proximate context for the specific allegations of genocide claimed by South Africa lies in the events of the 7th of October, when Hamas militants and other armed groups and individuals stormed into the internationally recognized sovereign territory of Israel and committed acts of barely credible atrocity. It was these events that truly constitute the real context for South Africa's allegations. Indeed, such acts may be seen as the real genocide in this situation. As the President of the European Commission put it on the 19th of October, there was no limit to the blood Hamas terrorists wanted to spill. They went home by home. They burned people alive. They mutilated children and even babies. Why? Because they were Jews. Because they were living in the state of Israel. And Hamas's explicit goal is to eradicate Jewish life from the Holy Land. These terrorists, supported by their friends in Tehran, will never stop. And so Israel has the right to defend itself in line with humanitarian law. Of course, these atrocities do not justify violations of the law in reply, still less genocide. But they do justify, mandate even, the exercise of the legitimate and inherent right of a state to defend itself, as enshrined in the UN Charter and under customary international law. To put an end to the continuing attacks against it and to prevent them from succeeding. A threat that has been made explicitly by Hamas and repeated, and it is thus real and imminent. This context is critical, for it shows that the true nature of the situation as it has unfolded, particularly the 7th of October, is that of an armed conflict. A heavily armed militia and its allies precipitated egregious hostilities, and the consequences lie everywhere. Point is this: armed conflict, even when fully justified and conducted lawfully, is brutal and costs lives, particularly when the militia in question specifically targets civilians and civilian facilities, and when it is patently unconcerned about causing civilian casualties on its own side. The conflict is also regulated by law, the rules and principles of international humanitarian law under the Hague Regulations, the Geneva Conventions of 1949, and customary international law. These are well developed and applicable and are fully respected by Israel. Such rules cover permitted activities under international humanitarian law, where civilian damage and loss, always to be regretted, are caused in the legitimate pursuit of military objectives through to the violation of the law, being grave breaches of the Geneva Conventions and up to war crimes and crimes against humanity. However, the only category before this court is genocide. Not every conflict is genocidal. The crime of genocide in international law and under the Genocide Convention in international law is a uniquely malicious manifestation. It stands alone amongst the violations of international law as the epitome and zenith of evil. It has been described correctly as the crime of crimes, the ultimate in wickedness. Indeed, the court itself emphasized in its order of the 2nd of June 1999 that the threat or use of force cannot in itself constitute an act of genocide within the meaning of Article 2 of the Geneva Convention, and particularly instant bombing, as lacking the element of intent in the circumstances. To put it another way, if claims of genocide were to become the common currency of armed conflict, whenever and wherever that occurred, the essence of this crime would be diluted and lost. I turn now to the question of the prima facie jurisdiction of the court in the matter before us. Article 9 of the Genocide Convention, to which both states are parties without reservation, makes the court's jurisdiction conditional on the existence of a dispute relating to the interpretation, application, or fulfillment of the Convention. And the relevant date for determining the existence of such a dispute is the date on which the application is submitted to the court. Whether or not a dispute in these terms exists at the time of the filing of the application is a matter for objective determination by the court. It is a matter of substance and not a question of form or procedure. The court will take into account, in particular, any statements or documents exchanged between the parties, as well as any exchanges made in multilateral settings, the court has said. The key point here is the use of the term exchange between the parties. Unilateral assertion does not suffice. There needs to be some element of engagement between the parties. The element of interchange and bilateral interaction is required. A dispute is a reciprocal phenomenon. This point has been consistently noted by the court. For example, the court reaffirmed in the Myanmar case the view that it had expressed earlier, that in order for a dispute in the sense of Article 9 to exist, it must be shown that the claim of one party is positively opposed by the other. The court further referred in the Marshall Islands cases to the need that the respondent should not be deprived of the opportunity to react before the institution of proceedings to the claim made against its own conduct. Where a state makes an assertion concerning the conduct of another state, it must thus give the latter a reasonable opportunity to respond before resorting to litigation, particularly in a matter of such severity as an accusation of genocide, and particularly before a court of this standing, and it behoves that state to provide supporting evidence of some credibility. Here, South Africa cites only a couple of general public statements by Israel, referencing merely a press report by Reuters and a publicity release from the Israeli Ministry of Foreign Affairs. These responses were not addressed directly or even indirectly to South Africa. There is no evidence of positive opposition as required by the court. Further, South Africa cites no relevant exchange between the parties, which would be the normal fashion for the expression and determination of a dispute between states. This actually typifies how South Africa has approached this matter. It seems to believe that it does not take two to tango. It is sufficient if one state determines there is a dispute, leaving the other party flummoxed. Professor Dugard explains that South Africa had voiced its concerns in the Security Council and in public statements and had further referred the matter to the International Criminal Court. At that point, he says, it became clear there was a serious dispute between the two states. The court has emphasized that in the case of statements made by one state in a multilateral forum, the court must give particular attention inter alia to the content of a party statement and to the identity of the intended addressees in order to determine whether that statement, together with any reaction thereto, show that the parties before it held clearly opposite views. South Africa's actions were insufficient. Indeed, in the Marshall Islands cases, the court, referring specifically to a statement made at a conference, noted that it did not call for a specific reaction by the UK, and thus no opposition of views can be inferred from the absence of any such reaction. Specific reaction. It is thus disingenuous for Professor Dugard to conclude that Israel must have been aware from South Africa's public statements, démarche and referral to the ICC of Israel's genocidal acts, that a dispute existed between the two states. This is not a dispute, it is a unispute, a one-sided clapping of hands. Professor Dugard perhaps tries to retrieve the situation by declaring that special considerations apply to the existence of disputes concerning Article 9, without telling us what those conditions could possibly be. We come now to the rather bizarre story of the exchange of note verbal. Professor Dugard would have us believe that such exchanges are merely a matter of courtesy of little real consequence. This is not the normal understanding of such notes and their importance in international relations, but he says this for a reason, as we shall see. South Africa instituted proceedings against Israel on the 29th of December. In its long recital, the application notes that on the 21st of December, South Africa sent a note verbal to Israel, raising its concerns about genocide in Gaza. The application further states that Israel has not responded directly to South Africa's note verbal. This is incorrect. Israel did indeed respond that very day, informing South Africa that the note verbal has been forwarded to Capital and that a response was expected shortly. South Africa confirmed the next day that it had received the message. On the 26th of December, the Director General of Israel's Ministry of Foreign Affairs proposed to his counterpart in the Department of International Relations and Cooperation of South Africa by text to schedule a meeting at his earliest convenience in order to discuss the issues raised. On the 27th of December, the embassy sent to South Africa by email a note verbal suggesting a meeting of respective Directors General at the earliest convenience in order to discuss the issues raised. An attempt by the embassy to hand-deliver the note was refused due to a national holiday, and the South African Department of International Relations specifically advised the embassy on the 28th of December to hand-deliver the note on the 2nd of January. The application was instituted on the 29th of December. This was an attempt by the State of Israel in good faith to open a dialogue and discuss South Africa's concerns. However, not only was this ignored at the relevant time, but South Africa proceeded to institute proceedings the following day and declared in its application that no reply had been received to its note verbal, which was patently not the case. Perhaps realizing the effect of this, South Africa, with some haste, sent a note verbal on the 4th of January, which essentially just repeated the contents of the note of the 21st of December, but it explained the following day in a letter to the registrar that the Israeli note had not been received by the appropriate team. Israel has proof of receipt. It also stated that the dispute is plainly not capable of resolution by way of a bilateral meeting. Nevertheless, it suggested to hold the meeting the next morning. Israel replied the next, expressing surprise that South Africa had instituted proceedings without taking up a sincerely made offer to hold consultations and conveying its wish for discussions to be held following the close of these oral hearings. South Africa, in a note dated the 10th of January, summarily and surprisingly, in the circumstances, said there was no point in such a meeting. Curious indeed. South Africa decided unilaterally that a dispute existed, irrespective of Israel's conciliatory and friendly response since repeated. Perhaps had South Africa taken up this offer, at the time proffered as a result of its own note, the parties may have decided there was no dispute as such to place before the court under the Genocide Convention, and that South Africa's expressed concerns over the genocide allegation would have been assuaged. We may never know. South Africa's precipitate institution of proceedings foreclosed that option. It's a point worth underlining. South Africa did not give Israel a reasonable opportunity to engage with it on the matters under consideration before filing its, no doubt, long-prepared application. One wonders whether South Africa, at the very last moment, suddenly realized that it needed to show the existence of a dispute under the terms of the Genocide Convention and proceeded to hastily formulate and dispatch a flurry of notes. The court can grant orders for provisional measures only where the provisions relied upon by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded, although it need not satisfy in itself in a definitive manner that it has jurisdiction as regards the merits of the case. It's not an easy matter to determine whether a prima facie case exists. It rests between full proof and complete absence of proof, and is intended to ensure that the court functions effectively and efficiently, but there has to be something tangible in terms of the provisions in question. The provisional measures procedure is a complex instrument in that the court has to decide upon the basis of certain assumptions which may or may not be disproved at a later stage of the proceedings. This is particularly difficult in such an egregious matter as an allegation of genocide. Were understood by the, I've lost a page. Okay. Where the standard of proof at the merit stage is high, the court having made it clear that claims against the state involving charges of exceptional gravity must be proved by evidence that is fully conclusive. That is not the case, of course, at the provisional measures stage, but it's also not negligible. The court is asked to grant, in this case, a number of measures that in effect assume that the party in question is committing genocide. As Mr. Staker will show later this morning, mud is thrown at a stage before conclusive proof, and it may stick even if the accusation is comprehensively disproved at the merits phase, as we expect. A serious political and security price may be paid by the grantee of such measures, even though it may later be shown to be completely unwarranted. This must surely require that the court acts with caution and understanding, particularly in evaluating the components of the allegation in law. Provisional measures are intended to constitute a shield and not a sword, to preserve, not undermine, rights. We have shown that one element of Article 9, that of the need to demonstrate the existence of a dispute, as understood by the court in the light of its case law, is lacking. The second element concerns the question as to whether the act complained of by the applicant can be seen as falling within the provisions of the Convention. The court has noted that only at the merit stage can it be determined whether the provisions in question of the Convention have been violated. To accomplish this, the necessary specific intent to destroy in whole or in part a national, ethnical, racial or religious group as such has to be proved. However, this cannot be read as a complete rejection of consideration of the intent criterion for current purposes. The court in the Myanmar case noted that a finding of violations at the merit stage notably depends on the existence of intent, notably, not exclusively. Myanmar is not a ruling that intent is irrelevant in a consideration of prima facie jurisdiction. It is a ruling that in conclusion as to whether or not violations have actually occurred is a matter for the merits which notably depends on an assessment of intent. This clearly leaves open the possibility that intent is indeed a factor in determining prima facie jurisdiction in provisional measures proceedings. This also comports with the logic of the situation. The Act's elements of the definition of genocide are listed in Article 2, and for present purposes there is no need to go through them. The issue is this: what determines the existence of the crime of genocide is the intention to destroy, in whole or in part, a particular group as such. That is what distinguishes genocide from other international law crimes, such as war crimes or crimes against humanity. To consider the act alone, as listed in Article 2, with no reference at all to the intent criterion is thus to denude the crime of its very essence. Hamlet without the prince, a car without an engine. We are at the provisional measures phase of this case. South Africa does not have to prove that genocidal acts have been or are being committed, but it does have to show that the Genocide Convention is in play. After all, this court has no jurisdiction to consider any other alleged crimes, however serious. We are only concerned with genocide.